Imagine walking into your sheriff's office to apply for a concealed carry permit, and they tell you, sorry, you don't qualify enough. That wasn't fiction. That was real life in places like New York and California until now. The Supreme Court just issued a ruling that's making major waves across the firearm community. And if you carry or even plan to, you need to hear this. Welcome back to Firearms Law Advisor, where we cut through the noise to bring you what actually matters for responsible gun owners. Today's story is about rights, responsibility, and a 6-3 Supreme Court decision that's changing how concealed carry laws work in America. This isn't just legal news, it's a shift in how we legally carry and protect ourselves. Let's get into it. Part 1. The 6-3 ruling explained. The case was New York State Rifle and Pistol Association versus Bruen, a challenge to New York's long-standing concealed carry law. For over a century, New York required applicants to show proper cause to carry a concealed firearm in public. But here's the issue. Self-defense wasn't considered good enough. You had to prove some extra level of risk, like being stalked or facing a specific threat. If your reason didn't meet the state's narrow standard, your application was denied. But in June 2022, the Supreme Court ruled 6-3 that this law violated the Second and 14th Amendments of the U.S. Constitution. Writing for the majority, Justice Clarence Thomas made it clear, if a law limits your Second Amendment rights, it must be consistent with the Constitution's text, history, and tradition. In plain English, modern gun laws must be rooted in historical precedent, not based on what current lawmakers think is reasonable or necessary. This ruling set a new legal standard, and it sent a clear message. You don't need to prove danger to exercise a constitutional right. Part 2. What's changing across the states? This ruling did not just affect New York. It sent ripple effects across the entire country. States like New Jersey, California, Hawaii, and Maryland had similar laws that required citizens to justify why they needed to carry a firearm. These states used a may-issue model, where approval was subjective and often denied without a clear reason. Now, after the Supreme Court's decision, many of these states are being pushed toward a shall-issue system. That means if you meet the basic legal requirements, such as passing a background check and completing training, you must be approved. There is no longer room for personal judgment from local authorities. However, some states are responding with resistance. Instead of eliminating restrictions, they are building new legal frameworks that create more obstacles. These include extended waiting periods, more expensive and time-consuming training, and strict rules on where you can legally carry. In response to the ruling, New York passed a revised law that designates a long list of sensitive locations. These include Times Square, public transportation, parks, bars, libraries, and houses of worship. Critics argue the list is so broad that it makes legal concealed carry nearly impossible, even for permit holders. When this new law was challenged, the Supreme Court chose not to intervene at this time. As a result, the debate continues in lower courts where legal challenges are actively underway. One thing is certain, the ruling may have set the stage, but the fight is far from over. Part 3. Text, History, and Tradition. The new legal test. The most important part of the Supreme Court's decision is the new legal standard it created. From this point forward, courts reviewing gun laws must ask a very specific question. Does the regulation align with the Constitution's original text? And does it reflect the history and tradition of firearms regulation in early America? This means judges can no longer rely on modern ideas about public safety or current policy preferences. Instead, they must look to how guns were regulated during the 1700s and 1800s. So if a law restricts things like magazine capacity, bans certain types of firearms, or limits where people can carry, it must be backed by clear historical examples from that period. That is a very high bar to clear, and it is already having a real impact. Several federal courts have struck down modern gun laws, including magazine limits and transportation restrictions, because they could not find any equivalent laws from the founding era. This new test, text, history, and tradition, is reshaping how the Second Amendment is applied across the country.